Hey everyone, I'm Mike Dahl. I'm one of the lawyers here at Valent Legal. In one of our most recent videos, we talked about what type of damages you can expect in a wrongful death insurance claim. I want to thank everyone who's left questions and comments on the posts below. A lot of those questions have revolved around the difference between, or trying to understand the difference between medical malpractice and a wrongful death claim. And so today I want to clear that up and help explain. For even more information, you can check us out at www.valentlegal.com or follow us on Instagram, where we'll post more helpful information about insurance claims. One question we're often asked is, what is wrongful death at law? And the concept is quite simple. It's where someone's wrong, tortious actions has resulted in the unfortunate premature death of another. And so a common one that we see is negligence. So if someone sort of drives or treats a patient in a manner that is below the standards that we can expect of a driver or a physician, and that negligence, that substandard action or actions result in the death of a loved one, let's say, then the family members have a claim for wrongful death and are entitled at law to the damages that they have suffered as a result of the wrongdoer's actions or, in some cases, omissions. Medical malpractice means essentially negligent medical care. All doctors and all nurses are held to a standard of a reasonable practitioner of their education, training, and experience. And so, for example, an orthopedic surgeon has to live up to the standard of a reasonable orthopedic surgeon. A nurse, an ER nurse, has to live up to the standards and expectations of a reasonable ER nurse. And so when they see a patient, they have to treat that patient pursuant to those standards. If they don't, then they are negligent. And if that negligence results in an injury or death, then they are at law liable and responsible for compensating for that injury or death. Some of the more common types of medical malpractice that we see relate to things like misdiagnosis or a late diagnosis, or a surgical procedure gone wrong. Unfortunately, most surgeries carry with them some degree of risk, but oftentimes the injury or the consequence of the surgery is not within that degree of risk, that the outcome was not foreseeable and was likely, therefore, as a consequence of substandard care. Another common type of medical malpractice that we see is a late diagnosis, where effectively a patient comes before a medical professional with a certain set of symptoms. It's that medical professional's obligation to do what's called a differential diagnosis, to think about all of the possible medical explanations for those conditions, for those symptoms, and then to systematically eliminate the most harmful, the most life-threatening conditions until they come to the most likely diagnosis, the most likely differential. Then they, as a medical professional, have to treat the symptoms, of course. And what happens, we see unfortunately sometimes, where doctors don't go through those necessary steps to properly diagnose a condition, to properly diagnose the symptoms. And then what would happen if you don't diagnose the symptoms, you don't treat the symptoms, and harms and unfortunately death can sometimes result, or it takes too long to treat the symptoms, and then the same negative consequences can result. If you've lost a loved one as a result of medical negligence, of medical malpractice, in order to be compensated for your harms, in Canada it is required that you commence a civil action. The type of insurance that doctors have don't permit compensation to flow unless the family has a lawyer in an active lawsuit and has taken the steps to prove the essential elements of the claim. And so the process to initiate that is to speak with an experienced medical malpractice lawyer, have the case reviewed. Most lawyers will do that free of charge. Have that case reviewed on the merits, which will in many cases involve that lawyer dealing with experts behind the scenes who will review the medical files, the medical charts, and give an opinion on the strengths or weaknesses of an allegation of medical negligence. Once you get that initial opinion, if it comes back and says you have an arguable medical malpractice case, then you can advance a claim. Lawyers that specialize in this stuff successfully will represent family members on a contingency basis, meaning at the end of the day, if the lawsuit is not successful, the family doesn't have to pay any legal fees. And lawyers that specialize in this stuff will also pay out of their pocket the money that's required to make the case successful. And what that means in medical negligence cases is pay for the medical experts to provide the opinions that are necessary at law to prove the case. Proving medical malpractice is easier said than done and often requires an experienced lawyer in your corner. You need, at law, experts to support your allegations. It is not enough as a patient or a family who's lost a loved one to allege medical malpractice and let the courts figure it out. You have an evidentiary onus. You have the onus of proof to establish the three elements that need to be established for a successful case. First, was the doctor or nurse negligent? Did he or she breach the standards applicable to his or her profession? 2, did that cause, 3, an injury or death? The first two elements, breach of standard of care and causation, are medical inquiries. They require medical experts. And without a medical expert to support the allegation, then you just simply cannot be successful in your medical negligence claim. Experienced medical malpractice lawyers work with these experts all the time. Folks often come to me saying, look, how am I going to find a doctor to support my allegations? Aren't all doctors buddies? Aren't they going to circle the wagon around each other? And that's true. Except in Canada, there are a lot of doctors who are willing to speak out when they see negligence. Oftentimes, they won't. You will have to go outside of Nova Scotia or outside the province in which your case is being brought. It is a fact that it can be difficult to find a Nova Scotia doctor willing to go on record to say that another Nova Scotia doctor of his or her specialty fell below the standard of care and that failure caused a really negative consequence. That is difficult to do, but experienced medical malpractice lawyers know where to look and know which experts, which medical specialists are willing to call it like they see it and offer a supportive opinion in the event they believe that a doctor fell below the standard of care. Just like every civil claim, every civil lawsuit, there's a limitation period that applies to when you have to file your claim by. And for medical malpractice cases, that's 2 years after you know or ought to know that you have a possible claim. And so if you have suffered an injury or if a loved one has lost his or her life as a result of medical treatment that you believe to be substandard, it's from that date that the clock starts ticking. And it's a 2-year clock. On the one hand, it doesn't provide an indefinite period, but 2 years gives most patients and most family members enough time to do what they need to do in order to assert their claim of negligence. Thanks everyone for watching today's video. I hope I was able to answer some of the questions that you may have about starting a medical malpractice claim. What is the difference between such claims and wrongful death claims? Happy to answer any comments or questions down below, and feel free to check out any other videos on our site.